This lecture summarizes the materials covered in Chapter 6 of the textbook, which deals with civil litigation and alternatives. There's quite a bit of information in this chapter, and just by way of warning, this chapter covers what is dealt with in two one-semester classes at Cerritos College, Law 100, Civil Procedures Before Trial, and Law 102, Advanced Civil Procedures. It also touches on matters that are covered in our alternative dispute resolution class. So again, there's quite a bit of information in here. This is just an introduction to the civil litigation process. There are a number of forms that have been posted in the modules that I'll be referring to. This is the module for Chapter 6. There are examples of various pleadings, discovery forms, and the like. There are also links to videos which demonstrate various trial procedures and discovery procedures. So I'll refer to those videos as we go on, and I highly recommend that you view those videos along with the materials that are contained in the modules. The first thing we cover in this chapter is ways to avoid litigation, or at least avoid going to trial. And this refers to various forms of alternative dispute resolution. We use the shorthand term ADR. Again, alternative dispute resolution is a class that's taught at Cerritos College. In and of itself, we have an entire one semester class. ADR refers to techniques for resolving conflicts other than full-scale litigation. ADR is increasingly popular way to resolve disputes amongst parties. And those in favor of ADR point out the fact that it has the ability to resolve conflicts more rapidly and lesser costs than litigation. The two most common types of ADR, as outlined in the slide, are arbitration and mediation, and we'll highlight the differences between those two. Mediation involves a third-party mediator that's trained in dispute resolution techniques. This is the contrast with negotiation, which usually involves negotiations between the principals of the parties themselves, whereas mediation brings in this third-party mediator. And the mediator attempts to bring the people to a voluntary agreement. One of the big differences between mediation and arbitration is the mediator does not impose a settlement, does not make any rulings. The mediator's job is to bring people together to reach an agreement. There are some types of cases where mediation is actually required. The example of that is in the California child custody disputes. The court maintains a panel of mediators, and anybody involved in a child custody dispute is required to go through that mediation process. A mediation may also be required under contracts. For instance, the standard real estate purchase and sale agreement that's used in California requires mediation before litigation can be instituted. Again, as pointed out in the slides, mediation includes things like marriage counseling and any time where people are involved in future relationships. Arbitration, on the other hand, is essentially a private trial. And in arbitration, the parties submit their disagreement to a neutral third party who is an arbitrator. That arbitrator acts as the judge and the jury. And as part of the agreement, the parties agree to accept the arbitrator's decision, which is binding. Arbitration is common in business contracts, and arbitration is generally present where there's a written agreement between the parties who have agreed to submit any disputes to arbitration. There's an example of an arbitration agreement contained in an American Express contract in the modules that you can see. Arbitration is a favored remedy under the Federal Arbitration Act, and courts generally uphold arbitration clauses in contracts, notwithstanding a number of attempts, particularly in California, to object to them as being onerous or burdensome. We often see arbitration agreements in things like employee manuals, where an employee going to a new job is asked to review an employee manual, sign off on it, and that employee manual may contain an arbitration clause whereby the parties agree that any disputes arising out of the employment will be submitted to binding arbitration. And again, these are generally upheld. Arbitration can have a number of benefits. Again, normally it is quicker, and it is more streamlined and can be less expensive. Another advantage of arbitration is the parties are generally allowed to pick who will act as the arbitrator. So, for instance, it's a very complex construction dispute. The parties would be able to submit the dispute to expert contractor or an attorney or a retired judge that has experience in contract cases to have it resolved by somebody with expertise in the area. Disadvantages include the fact that there is generally no appeal from an arbitration award unless there's some kind of fraud involved in the arbitration process. Arbitration agreements are final and can be enforced under or by the courts. In the modules, there is an example of a catalog by a company called ADR Services. There are a number of services that have arisen as of late, offering arbitration and mediation services. Others include JAMS, used to be called Judicial Arbitration and Mediation Services, the American Arbitration Association, and the like. Most of the arbitrators and mediators on the panels of these companies are retired judges or very highly well thought of lawyers. One thing they all have in common is that they've all undergone training in dispute resolution techniques, particularly with respect to mediation, less so with respect to arbitrator. Another thing to keep in mind, particularly with respect to mediation, is that there's no requirement that a mediator be a lawyer. And in fact, when you think about something like child custody cases or marriage counseling, they're often more likely not to be a lawyer, particularly marriage counseling. Instead, they are people with training in dispute resolution techniques, again, that work to bring people together. Assuming that alternative dispute resolution does not solve a dispute, we end up in litigation. And litigation refers to the process of using the courts to resolve disputes. In California, the rules regarding litigation are generally contained in the California Code of Civil Procedure, abbreviated as CCP. In the federal courts, we have the Federal Rules of Civil Procedure, and we have model rules that are modeled after the federal system. Again, the model rules are not in place in California. No, instead, we have the California Code of Civil Procedure. At the pre-trial stage of litigation, the attorney must make many of the decisions we've already learned about in our studies, determining whether there are legal grounds for the suit, if they're standing, and whether or not the courts have subject matter or personal jurisdiction over the lawsuit. The lawyers also required to discover or think about who are the proper parties to the lawsuit. Are there any statute of limitations that might be involved? Are there administrative remedies that must be exhausted before filing suit? An example of administrative remedy would be if you want to file a lawsuit against a governmental entity in California, you're required to file a claim. And unless you go through that claims process, you are not allowed to file a lawsuit. Once the complaint is filed, a complaint starts the lawsuit. It has to be served on the defendant, and the defendant's lawyer then has to make a decision how they want to handle it. They may simply decide to answer to the complaint and begin litigating the matter, or they may file some type of pretrial motion to have the case thrown out of court. Examples of these types of pretrial motions are demurrers, motions to strike, and a motion for summary judgment. A classic example of why a demurrer might be filed is if there's a defect in the complaint that shows that it has no merit. Again, as pointed out in the textbook, a demurrer is filed when the complaint itself is defective and it just discloses a basis to have it thrown out. So if the complaint, for instance, was for a breach of an oral contract in California, the statute of limitations on claims on oral contracts is 2 years. If the complaint said that the breach occurred 3 years ago, a demurrer would be proper. The attorney would point out, look, Judge, even if everything disclosed in the complaint is true, it nevertheless should be thrown out. Again, let's resolve this case short of trial so the parties don't have to spend money. The motion for summary judgment procedure is a bit more complex, and I direct you to your textbook to learn more about that type of procedure. Through the litigation process, the parties have an opportunity to discover facts in possession of the other side, along with non-parties to the lawsuit. We call this discovery. The most common forms of discovery are written interrogatories, which are questions that are submitted from one party to another. Demand for production of documents and things. That's a procedure between parties to a lawsuit, whereby they demand the production of documents, physical things, and increasingly electronic files. Finally, depositions are a procedure whereby attorneys are allowed to ask questions not only of the other parties, but also witnesses, and ask them questions in a rather informal environment, but nevertheless in a way where the witness is under oath and their testimony is preserved through a written transcript. The deposition process is a very effective but also very expensive way of obtaining information from other parties and witnesses. There are examples of interrogatories, inspection demands, and depositions in the modules that you can see. Again, as we've learned in prior chapters, courts are not allowed to decide abstract issues. And in fact, there has to be an actual dispute amongst people who are personally affected by a court's decision. This is the issue of standing. So in the American system of justice, unlike many other countries, the parties involved in a lawsuit must have an actual personal stake, and otherwise the court will not consider the matter. As discussed earlier, statutes of limitations are important. They set forth the period of time within which something happens and when a lawsuit must be filed. Examples of California statute of limitations are on the slide. 2 years for assault and battery, 4 years upon a written contract, 3 years upon action for trespass, etc. You'll note that the statute of limitations are contained in California Code of Civil Procedure. And again, these are just three of many, many, many examples of statute of limitations. Again, if a complaint discloses on its face that an action is barred by the statute of limitations, a demurrer would be a proper way to attack the complaint. Again, the documents that start a lawsuit are pleadings. The complaint is filed by the plaintiff to begin a lawsuit. There are examples of complaints in the textbook and in the module for this chapter. The summons is a court form that informs a defendant of the lawsuit and the requirement to respond or lose. There are examples of a summons in the textbook. The textbook example is a federal court type of summons. There's also an example of summons, California State Court summons in the module. Again, typically, unless a demurrer or some other kind of motion is filed, the defendant would reply to the complaint by filing an answer to the complaint. The defendant may also bring in other parties to the lawsuit or file other proceedings or other pleadings. One typical pleading is a counterclaim, a claim brought by the defendant against a plaintiff. An example of a counterclaim might be, say, a material supplier submitted or supplied materials to be used in a construction project and wasn't paid. They sue the person that bought the materials, claiming that they're not paid. A counterclaim would be a claim brought by the person that bought the materials against the suppliers, saying, in my example, perhaps, I don't owe you any money because the materials you supplied were defective. And in fact, you owe me money. I had to go out and buy other materials at a higher cost. It caused a delay in the project, and you're responsible for the damages that occurred. Cross claims are a term where there might be multiple defendants, and one defendant brings a cross claim against another defendant in the matter. An example of that might be a construction dispute. Again, perhaps a developer sues several subcontractors, alleging that they performed their work improperly, and those cross subcontractor defendants sue each other for claims arising out of the dispute. A third-party claim, on the other hand, is where a defendant brings someone else into the lawsuit. Again, going back to my first example, where a material supplier is sued by the purchaser, a third-party claim might be, say that material supplier, say it was Home Depot, they would in turn sue the manufacturer who they bought the products from to bring them into the lawsuit. So again, lawsuits can become very, very, very complex through these different types of pleadings. Again, the complaint is the pleading that begins the lawsuit. The claims or the complaints are described in the textbook in great detail. Again, there's an example of a California complaint in the modules that you can look at, as well as examples of complaints in the textbook. One of the things that, again, is common in all complaints is a complaint description of the names and parties to the lawsuit, the nature of the lawsuit, and the type of relief sought. The answer to the complaint, again, this would be filed unless there is some kind of other attack, and answers take different types of form. Generally, they operate as a statement of denial of the material allegations of the complaint, admitting certain matters, or a lack of knowledge. Answers also commonly contain things that are known as affirmative defenses. Affirmative defenses are matters that serve to eliminate or at least lessen the defendant's fault. So perhaps, say it was a case of an auto accident, an affirmative defense might be something to the effect that the plaintiff was partially negligent and therefore partially responsible for their own injuries. Okay, figure 6.6 of the textbook is a pictorial description of these various types of pleadings you may find helpful. The pretrial motions, again, as I discussed before, the demur in federal courts is known as a Rule 12b6 motion. The motion for summary judgment this is has the same name under the federal rules under Rule 56. The different types of discovery, again, are summarized in the slide in front of you. Again, the interrogatories are questions that must be answered under oath by the opposing side. Interrogatories can only be exchanged between parties. You cannot send an interrogatory to a witness. Interrogatories can be very helpful in gathering information. For instance, a defense lawyer may ask the plaintiff to set forth in detail all the names, addresses, and telephone numbers of all witnesses to a lawsuit. The interrogatory may ask the plaintiff to set forth and describe all correspondence that refers to the subject matter of the lawsuit. So again, they're very useful, particularly in asking for a detailed information. Interrogatory may also ask a plaintiff to state all facts that support their contentions in their complaint. Again, requiring the defense or requiring the plaintiff's lawyer to set forth in detail each and every fact that they rely upon. Request for admission asks a party to admit or deny certain specific items. Again, a request for admission might be something like admit that on March 26, 2023, you were on campus at Cerritos College. If that request for admission is admitted, then the matter is conclusively presumed for purposes of the trial, and the plaintiff would not have to submit evidence of that fact. It's been admitted, it's no longer in dispute. Obviously, that's a very simple example, but request for admissions can be a very useful tool in the discovery process to narrow the items that are in dispute. Physical examinations are most often seen in personal injury accidents. A defense lawyer is generally allowed to require a plaintiff in a personal injury action to appear and be examined by a physician hired by the defense, a defense medical examination. These examinations don't happen in secret, and typically a lawyer or a paralegal from the plaintiff's firm would accompany the plaintiff to the defense medical examination to document what goes on. Again, these are just various forms of discovery. Electronically stored information is an increasingly important part of discovery, and this has become more and more important as more and more of our data is kept in electronic format rather than in paper. There's a good discussion of electronically stored information in the textbook, and I commend you to read that carefully. This is actually a very booming area of the law, and people with expertise in like we call it e-discovery, have a lot of employment opportunities. So again, I encourage you to review in detail the text materials regarding e-discovery. It is a very, very important part of the modern litigation process. Once the parties have engaged in discovery, they come towards trial. And in most cases, there will be something that's called a pretrial conference or a settlement conference or a mandatory settlement conference, where the parties will again get together, typically this time with a judge, and attempt to resolve the case. So this is another type of ADR, this time conducted by the court. As the text points out, the overwhelming majority of cases never go to trial, and they settle somewhere along the way, whether it's before a lawsuit is filed, shortly afterwards through some kind of mediation, and again, sometimes through the mandatory settlement process. These pretrial conferences also allow the parties to meet with the judge, determine what the case is all about, and again, outline and set forth what type of procedures are going to be used to try the case. Is it going to be a judge trial or a jury trial? If it's a jury trial, what type of jury instructions do we want? Estimates regarding scheduling. How long is the case going to take? The attorneys learned about the judge's different procedures regarding trials. So again, this pretrial conference is a very, very important part of the litigation process. The right to a jury trial depends on the court and the type of case it is. The Constitution does guarantee a right to jury trials, but that only extends to certain civil matters and basically matters at law. Equitable cases are not allowed a jury trial. In criminal cases, of course, most criminal cases do have the right to a jury trial, but defendants can and often do waive their right to a jury trial. Many of the defendants in the January 6th, 2021 cases that happened when the U.S. Capitol was stormed waived their right to a jury trial and have proceeded to have the case tried through a judge. The jury selection process, if there is a jury trials, is an important part. The text talks about the different types of challenges that attorneys may use in the jury selection process, and also points out the fact that people often now use experts to help them select juries. These experts are litigation consultants that will help lawyers decide what type of witnesses they want on the jury based on certain personality traits and those types of witnesses that may be more helpful to the case. Jury selection experts are used in all large litigation cases, whether it's civil cases or defense or criminal cases, and used by both plaintiffs' lawyers and defense lawyers, as well as prosecution in criminal cases and defense people. Once the trial commences, the trials start with an opening statement whereby the attorneys outline their theories of the case and what they expect to prove. The purpose of an opening statement is basically to submit a roadmap to the jury of where they're going. One of the reasons that an opening statement is important is because oftentimes witnesses are called out of order because of scheduling and the like. So the opening statement helps put the witness's testimony in context. You can see examples of an opening statement in the modules, or there's a short YouTube video that sets forth a model opening statement. The trial proceeds through direct and cross-examination of witnesses by the attorneys. There's a good description of a direct examination and cross-examination process in the textbook, and examples of direct examination and cross-examination in the modules. One of the things that's typical of cross-examination is generally cross-examination only consists of leading questions. A leading question is one that where the attorney is basically suggesting the answer. An example of a leading question might be the light was green, correct? As opposed to what color was the light. One of the rules of cross-examination is generally you only ask on cross-examination questions that you know the answers to. And if you know that answer, you can control it by asking the leading question. The worst thing you can do in cross-examination is ask an open-ended question and get an answer that is harmful to your case. So again, we do that through cross-examination. On the other hand, on direct examination, we are not allowed to ask leading questions. So if in an auto accident case, and if I was asking my client, the plaintiff, what color the light was, I would simply say, what color was the light? The plaintiff is then required to respond. Again, if I would have said to the plaintiff, my client, the light was green, wasn't it? The defense lawyer would properly object, saying, objection, leading questions. So again, there are good examples of direct examination and cross-examination in the modules. At the end of the trial are closing arguments. A closing argument is the time within where the lawyers are allowed to summarize the evidence that has been presented and argue it. Cross-examination or closing arguments are often the most dramatic part of a trial. It's where the lawyer is allowed to demonstrate his or her expertise in argument and highlight the matters that are helpful to their case and minimize matters that are hurtful to their case. So again, the closing argument summarizes it. At that point, the case goes to the judge or the jury if it's a jury trial. If it is a jury trial, there'll be jury instructions that go to the jury that instruct the jury how to apply the facts to the law. If it's a jury case, the jury renders a verdict. If it's a court case, the judge enters a judge. As noted in the textbook, in criminal cases, generally a verdict must be by unanimous jury, whether by an acquittal or a conviction. On the other hand, in civil cases, we normally do not require a unanimous jury. It's usually, in most states, it's a three-quarter verdict. So if there are 12 jurors and we have 9 for the plaintiff and 3 for the defendant, you get a plaintiff's jury verdict. Again, anything less than that would result in a hung jury. There can be post-trial motions after a trial. The different types of post-trial motions as described in the textbook. They may range from asking for an award to be corrected in some monetary amount, perhaps to have the dollar amount changed up or down, all the way to having a jury verdict thrown out based upon some argument of misconduct. One of the most common things that you'll hear the losing lawyer in a lawsuit state on the courthouse steps afterwards is, we thank the jury for their work, but we're going to appeal, and we're confident of appealing, winning on appeal and having the judgment reversed. In the real world, again, appeals do happen, but they're very, very rarely successful. The result of most types of appeals are an affirmation of the underlying judgment, but on occasion they can be reversed and remanded. As noted in the textbook and in the slide, appeals are limited, and they're generally limited to questions of whether or not a trial court conducted the trial properly. So the appellate court is looking towards questions of law as opposed to facts. Another way to put it would be if it's a traffic accident case, the Court of Appeal isn't going to make a new determination whether the light was red or green. That's something that was determined at trial, and is the Court of Appeal is not there to hear the testimony. Court of Appeal is simply looking at the transcript and determining whether the trial was conducted properly. Ultimately, a Court of Appeals decision may be published, and again, different types of cases result in different types of decisions, and there's a good description of that in the textbook. So again, to summarize, there's a lot of material in Chapter 6. It's a broad overview of civil trial procedures. Again, it doesn't purport to be a description of criminal trial procedures. I brought that in a little bit to show the differences. Again, if it's something you're interested in, the paralegal program does offer classes in these subjects, and if you're in a paralegal major, you actually are required to take the Law 100 and Law 102 classes that I discussed earlier. All right, this concludes this lecture. Again, please review the materials in the textbook carefully. They're very well written and very valuable.